Hi there, and welcome to Burn Media Ventureburn's webinar on estate planning for entrepreneurs, brought to you by Absa. Thank you for joining us for this webinar. We have a really exciting discussion planned for you. I want to also thank the sponsors for making this possible. When we think about our lives as entrepreneurs, and I myself am an entrepreneur, we tend to think of ourselves as being, almost unkillable, like we're never going to die. That's the sense that a lot of us have about ourselves. We work crazy hours, we push ourselves to the limits, and we never think about what happens if something does happen to us. And that's the sad reality for many entrepreneurs that are very, very thinly stretched and don't always think about what happens after they die. So today we're going to be doing that. We're going to be talking about estate planning and why it's really important to think about your affairs as an entrepreneur in case the worst happens to you. Joining me on this discussion, we have two experts in this area. First up, we have Johan Barnard. He has over 10 years of experience in the legal, fiduciary, and insurance industry. Now, I've learned so much from Johan just chatting to him before this webinar, and I know you will too. He's part of Exco for Absa Trust and is responsible for advisory, fulfillment, sales, and business development for the Absa Group across all fiduciary products and services. Joining us as well is Sinal Govender, who left the comfort of big corporate law years ago to create legal tech that people can actually understand and use. And I know that I am a fan of that. She's passionate about using technology in the legal space as a tool to change the socioeconomic landscape of South Africa. She co-founded LifeFile, a company earlier this year, which, among other things, helps people to do a better job at estate planning. So we're going to dive into what you need to do as a business owner when it comes to your estate, and we're going to be taking your questions at the end of this discussion. So please drop your questions in the chat box, tell us what you're thinking, and we'll be sure to include it. But first up, let's kick off with a question for Johan. Johan, thank you so much for joining us. Now, tell me, what is the worst that can happen to an entrepreneur who has done no estate planning, and what are your top tips for someone like me as an entrepreneur?
Roshi, let's start with, before we get to the top tips, I would maybe just want to mention some common mistakes people make when it gets to estate planning. That includes failure to budget, and it's almost applying that very principle that Warren Buffett is famous for, that don't save what is left after spending, spend what is left after saving. So that is key. Others include like not updating your will, not having enough liquidity in your estate, not managing your trust property correctly, and having very overcomplicated tax and estate structures. I think that those are, from an individual perspective, the key things that stand out. From a business perspective, I would say it's lack of business continuity, business plans, maybe lack of business insurance. Those are the big standouts. And Roshni, as you said, the biggest thing that can happen is actually leaving your family in a really bad position if you're not there anymore as the business owner. And where do we start? I always say start with the business owner, the jockey. I mean, we tend to forget behind every business is a human being. And for me, it's the first and foremost place to start, is to make sure that that specific business owner, his will is intact. He's got liquidity in his estate to make sure that the family is looked after. Worst thing that can happen is that you want your family to be dependent on the business for their survival. And worse to that as well, to add on to your question, is to say, what happens to the employees of the company if you don't have those type of things in place? So their families are then put under pressure, and the snowball effect of that is actually quite immense. So I would say, Roshan, that's kind of the key elements and risks if you don't plan properly. And I want to almost end off by saying, then we can look at sort of the business entity itself, by then looking at, where do I operate as a business owner? Do I do it in a company? Do I do it as a sole proprietor, in a trust, etc.? And those types of questions all play a fundamental role in putting your plan together. So Varashni, and as we go through this, I just need to emphasize, there's not a one size fits all to these things. And it's so extremely important that you actually take your unique business, your unique circumstances, bring it to someone that can actually look at it, unwind it, and just make something that's unique and tailor-made for you and your family and your employees, to make sure that you don't have that issue of having your loved ones being dependent on the business, albeit your employees having to lose their jobs and their families obviously being in a worse off position with you not having to plan as the business owner. So that in a nutshell sort of answers the main questions there first.
And I'm sure you have so much more to add to that, Johan, and we will be getting into it in more detail because I know that's a very complex area, and as you say, there's no one size fits all. But moving on to Sinal. Sinal, you've worked with entrepreneurs for many years, trying to help them grapple with these issues. What would you add to what Johan said? What examples or anecdotes have you seen that have illustrated this?
And in my experience working with entrepreneurs, I've definitely seen a difference between those who at least take the initiative to understand legal implications of what they're doing. I mean, the law is something that intersects with all aspects of our lives, and it affects everybody. You can't escape that. And what sometimes is disappointing is I think we lose it. Like Johan said, businesses are made out of people, and we forget that we are not immortal, and our death is going to impact both our families and our businesses. So I've also encouraged people and really been impressed by people who have thought that through, and they don't have to have all the answers figured out. I think Johan made a very good point that there are experts that hopefully can see you as an individual and find out what works for you. But it is important to even understand lots of the time when people say I or you or us, I always ask them, what does that mean? When you're talking about, this is my business, who's in the business? What is your role in the business? What kind of entity are you operating under? And from that point of view, I think lots of people who are wealthy think my family's going to be fine because I've got these investments, I've got these properties, I've made very smart financial decisions throughout my life. But what you hadn't touched on is, what about the immediate aspect of it? It takes a long time. Things like COVID, things like load shedding, things like just general service delivery hasn't helped an already broken structure where, for example, people don't understand the law. So they don't understand that you need to have an original will in order to start the process of winding up an estate. And I'm somebody who, when I try to get admitted as an attorney, had to have my original birth certificate, which of course neither of my parents had. And we living in this digital age where we don't have original documents. We don't see them important, but you've got to put a little asterisk there to say, when it comes to your will, you've got to have that original one, and you need to tell people and communicate with people and understand things like your property that you put into your estate, that can only be distributed once that estate is wound up. And that takes years sometimes. So having the right insurance in place can also be very important, both for your loved ones, but also for your business. I can't remember now, I think it was one of the auditing firms who sent their directors on a conference. Now that's not an uncommon thing. They all got into the same flight and that flight went down. Now, from a business point of view, you've got key people who are dying instantly. And from a business continuity process, we've seen a lot about these hacks. How does your business continue if there's a data breach? But I guess my challenge for any entrepreneurs is to think, have you ever had a conversation with key stakeholders that say, if all of us had to die simultaneously, especially COVID has highlighted that it's not an unrealistic thing that can happen to business. What is our plan in place? Do we have insurance over those key people? Do we have insurance over things that maybe somebody has owned in their individual capacity, which now will go to their estate? But then what happens? Where do employees go to work? What happens to their salaries? And there's lots of banks that offer specific insurance products around this. And I think being curious and inquisitive, understanding these things, whoever's attending this webinar, well done. I think you're already 80% of the way there to express an interest in learning about these things. So I think that's where I would start.
Well, that's super useful. I mean, there's so much to unpack there. And the idea of all the directors, going down in a flight just sketches out how severe these situations can sometimes pan out. So thanks for that, Sinal. Johan, we're talking about different mechanisms, there's tailor-made solutions, there's different mechanisms. Something that you've got a lot of experience with is trust. Now, there's a lot that we can say about that as well, but can you give us a basic primer? How should we use trust as part of estate planning, and what are the potential pitfalls to look out from a tax perspective?
There's not enough time, but let's try and get this cracking. If you could just please share that article that we with the listeners, Roshni, because that is a good summary of why trust is still important. So I'll just try and summarize that version as briefly as possible. But if used correctly, and I think that's the operative word, if used correctly, trust still makes excellent business sense from an estate planning perspective. And that is then used to, house your assets and obviously to build generational wealth. But whether you do an inter vivos trust, a testamentary trust, there are a number of factors that needs to be taken into consideration, like the nature of the assets, the age of the intended beneficiaries, the intention of what you've envisioned with these assets and their use, etc. But I think, Roshni, what people have come to put trust against is a tax avoidance mechanism, if I want to call it that. But unfortunately, those days are gone, and Mr. Kieswetter and SARS and his team are ready for us when we think we're going to use a trust in that manner. So I always say, if used correctly, a trust is still a fantastic tool. And I always say it's asset protection that needs to be highlighted, not tax avoidance. And I think if we get that principle right, a trust is still a fundamental tool. So in answering that question of how you can use it, I'll just use two brief examples. If you have minor children that you want to nominate as heirs in your estate, and that could be a simple question of having a cash bequest or something of sorts. It makes sense to then set up a testamentary trust in your will, and then in the event of your passing, the trust will be registered, and any assets then bequeathed to that trust will then be transferred into that entity and managed for and on behalf of the beneficiaries by the trustees. So that is just a very brief example of a testamentary trust formed at death that is then used for the minor beneficiaries. You could also have the simple example of where you want to use a trust whilst you are still alive, and that is typically used where you want to transfer fixed property or a holiday home of sorts that you want to leave for your family, for generational use, if you want to call it that. And that's where typically an inter vivos trust will play a vital role. Because this property will generally increase in value over time. The effects of capital gains tax and estate duty will then obviously increase the costs of transferring that property to your children. So it is vitally important that we first and foremost, as I say again, not one size fits all, but if used correctly, a trust then will still play a vital role. And if we just go back to that example, by purchasing that asset in a living trust where your children are the beneficiaries, the assets effectively never sits inside your personal estate, and hence your children will receive that asset without having to incur these unnecessary taxes and costs. And the taxes with trust in itself is a topic on its own, but it's just worthy of noting that a trust is liable for income tax, which includes capital gains tax. So hence your SARS will require you to register your trust for tax purposes. And it's just very important to note that a trust pays tax at the highest levels at this current stage. Sort of the highest individual bracket is sitting at 45%.
Wow.
And that is what a trust will pay at. Whereas, individuals pay at that, sort of rolling sliding scale. And hence it's just important to note that if you use trust for planning, it's not always to say that the trust setup is tax efficient because of all what SARS have introduced over the past. So it's just vitally important that we understand that consequence and use a trust for its right purpose. And I think if we stick to those guidelines, we will be fine.
I mean, how long has it, how many years has it been of these tax regulations changing? Because it feels like a lot of South Africans are quite stuck in the a stage where trusts were perhaps seen as a bit of a silver bullet, right? To pass assets on in a way that was tax efficient, that would avoid certain red tape. How long has it been since that's changed quite a lot?
Varoshni, these things change quite a bit. And if we maybe just take a stab, take 2 steps back, I think where our problem lies with trust currently, it's not the instrument itself. You can always say you can have the best written trust deed in the world, but it all boils down to the administration of that trust. If we don't have our resolutions in place, our meetings in place, and because, as Sinal has said, I mean, the law dictates that the trust is governed by contract law. So you need to have your regulated meetings, etc., as said in the trust deed, and have it in that fashion. If you don't do it in that fashion, it's actually irregular. And I think that's where most trusts fall foul, is that we don't have our trust administration in order. And that's when things like tax, etc., comes to bite you. But I think that's the points I want to make, is that SARS have noticed over the years, we've been using these tools and mechanisms incorrectly. And rightfully so, they've come in and actually closed some of those doors. But I fundamentally feel it's still part of a holistic financial and estate planning sort of plan for an individual,
if it's
entrepreneur.
Right.
Yeah, and it is so
right
important to...
Yeah, so I think maybe there was a time when people were using it willy-nilly, but like you said, use it as part of a toolkit. Now,
100%.
so I want to come back to you. There's so many different parts to that toolkit. There's so many different parts to the process that we as entrepreneurs need to think about when planning. And one thing we tend to do as entrepreneurs is kind of jump into business with each other without often getting that shareholders agreement right. What are some of the things that can go wrong if you don't do that right? And what is the importance of the shareholders agreement in terms of estate planning?
Well, I think what, just to touch on what Johan has just been saying, is you need to also understand what are your intentions behind everything that you do. So when you look at things like, is it about asset protection? Okay, now that's going to direct how we structure our own individual estates and our business when we're going forward. Or is, for example, when people set up companies, it's quite straightforward. And in fact, I think you can do it through most of the banks now as well, that you can register a company through CIPC. But what people don't realize is that CIPC issues a standard memorandum of incorporation, but it doesn't provide a shareholders agreement. So the shareholders agreement, like a trust document, like a trust deed, that really is the roadmap, the bones of a business that says, if this thing happens, this is how we're going to resolve it. We've seen a few cases now where there has been a deadlock with shareholders, where they cannot agree to what they need to do, but there's no deadlock mechanism in place, which means that it triggers a liquidity event where the court can actually say, we're going to liquidate the business. Now, these are businesses that are really profitable. They are on the up, but the court is saying there's a shareholders deadlock and the shareholders can't resolve it. And this is what happens because people are involved. There are people who have egos, who have their own ways of doing things. And if they cannot agree to something, the court can actually wind up that company or order it to be placed in business rescue. So to that end, when you look at in the absence of a shareholders agreement, if a shareholder dies, their shareholding is an asset that forms part of their estate like anything else. And what you should be having, what you should be considering is saying, in the best interest of the business, those shares will absolutely fall into the estate of that person, as it should. However, in order for us to really leverage the business and continue with the business, that those shares must be offered to the existing shareholders. You know, that's a provision that you can put into your shareholders agreement, and they can compensate the estate for that. So it's not that the estate is losing out. The estate is getting the finances, but without inheriting a shareholder that those original shareholders didn't intend to inherit. I think what can be worse is when people, like Johan said, it's simple things like not updating your will. So you start a new business, but then you don't update your will, and you get divorced. You don't update your will. Now, the South African law has a presumption where for 3 months after you get divorced, they presume that you don't want your ex-spouse to inherit. So they will take it as though that spouse is not part of your estate or beneficiary of your estate. But after those 3 months, the court says you've had enough time to get your affairs in order. And this is what happens. You have ex-spouses inheriting access to businesses. And I mean, I don't want to assume the worst.
Seriously.
Absolutely. You know, an opportunity here or a possibility where you are now having to engage with not your deceased shareholders' family, but your deceased shareholders' ex-spouse who could purposely make things quite challenging for you. So it's just about being on top of admin. That's what I think is the best skill for any entrepreneur to do, is to be on top of their admin, making sure that have we got a shareholders agreement in place? Does it account for these sorts of things? What happens if one of us dies? Have we updated our will? You know, sometimes these shareholders agreements take a long time to finalize, but there are things that you can do in the meantime to say, well, why don't we as business owners agree that in both of our wills, we're going to update them so that the respective business partner gets the shareholding. So you can allocate, you can partition your estate to say, all my shares in company ABC will go to this shareholder, but all my property will go to this person, all my cash will go to this other person. So like I said, there's no one size fits all approach. But I think the first thing is to understand what assets do I own? And it's not just about your car, the cash in the business, the house that you live in. You know, your assets can be so many different things. And it's really, really understanding what you own in order to understand what would happen to all those things when you die.
I mean, Sinal, we're going to get on to what different kinds of ownership are, but later in the conversation, things like, I know you're very passionate about intellectual property. But before we get to that, what happens to people who, go out and start a business as the sole director, and they don't have a shareholders agreement in place because it's just them, and then they pass on?
Yeah, I mean, that's a really important point. And maybe just going one step back, like Johan said, there's lots of different structures. So there are lots of people, because they are only one person, they operate as a sole proprietorship without understanding that there's no separate legal personality between you that's going home to your family and what needs to happen to them after you die, and also then what happens to your business. And that can become a huge problem. Just to quickly touch on that, in terms of there are creditors that wait in line, and before the beneficiaries get paid, those creditors need to have their debt satisfied. So when we're talking about trust structures, when we're talking about registering a company, it's also about understanding that if, for example, I'm in a business, and that business, maybe especially in 2021, cash flow is a problem, we're needing to take out these extra loans, take on extra credit, you need to understand that those creditors, when that company is being liquidated or something goes wrong there, that those creditors are first in line, and likewise with your own individual estate. So having things like a shareholders agreement in place, trying to figure out what directors can and can't do, what shareholders can and can't do, you're also protecting or minimizing the risk of, if somebody does something and then they die, is it going to be that their remaining shareholders and directors have to step into their shoes in order to satisfy things that they might have done? Or is it going to be their individual estates? And a shareholders agreement is a wonderful thing where you can pretty much, as long as it's not foul of the law, pretty much agree on anything. And being able to just have this roadmap, and that's what an agreement should be, any agreement. For example, it's not just about a shareholders agreement. You have a service level agreement with the service provider. Now, what happens when they die? If I would encourage anybody who's got rental property at the moment, both in their individual capacity and in their commercial leases, most lease agreements will say, if you die, you're not absolved of your liability to pay your rent. Your estate must step into this. So it's these sorts of things that people need to keep going into these agreements and looking at. I don't think enough people pay attention to how does this agreement terminate and what happens when it does. And
I don't think people at all think about that. I think we all,
so it's not my problem, but it can be like a real mess for people and
for your loved ones, right? Like when you think that you're immortal and you don't, have the wherewithal to deal with the admin, I think a lot of people are averse to dealing with that kind of personal admin. It affects your loved ones most. But now we'll come back to you shortly. Just talking about wrapping up things and, getting those processes in place. Johan, we know that there's a lot of stages to the process when it comes to winding up an estate. And part of that process is a legal one with the state itself, with our government. But we know that government processes are less than optimal a lot of the time. So we're sitting here today glad that we don't have load shedding. You might have had water shedding, we don't know. So the state itself has severe challenges. So what are some of the challenges when it comes to things like getting estates wound up at the master's offices and so on, and what can people do to ensure their loved ones are covered should they pass on while those processes are happening?
Yeah, thanks, Varashni. Looking at the master's office, unfortunately, they've made the news the last couple of weeks and months for all the wrong reasons. And as you rightfully said, the master's office is the starting point of the estate administration process, once a person passes away. And because of the recent hack we read about, because of COVID-19, most of these master's offices have been closed, and thus that letters of executorship cannot be issued. So it becomes important to note that the executor or the estate administrator cannot do anything without these letters of executorship. So families will not get access to their money in the estate. Policies can't pay out, debts can't be settled. And this leaves the family in a state of limbo, if I can put it that. So, whilst we've read that the master's office have slowly but surely started reopening and kind of fixing their systems, there's an extreme backlog at this stage. And it's going to take a good couple of months, in my opinion, to actually get rid of this backlog. So the biggest tip or piece of advice I can give our listeners is to actually provide for your family by having sufficient cover in place and making sure that there is liquidity for the estate. But the biggest thing here is to make sure that there's a beneficiary nomination on life insurance policies, either existing, or if you're going to take out new, make sure that you actually nominate a beneficiary on your insurance in order for that money to get paid out outside of the estate, so that we are not dependent so much on the master and that administration process. So, most of the issues that we're currently dealing with is because of that lack of, the letters of executorship and then us being able to continue in that administration process. So, the entire fraternity is sitting in that position. And I'm just saying, let's take control of the controllable and let's speak to our financial advisors, make sure that our existing policies, or if we don't have cover, let's get a full financial plan intact, get that life cover that'll look after our family, so that, as entrepreneurs, we don't, we know that, we've got peace of mind that our family doesn't have to go knock at the business door. And we know that, as Sinal rightfully said, in some instances it will take months, years, maybe even to wind up these estates. So let's get that money paid out quicker so that our families can continue with their lives. And I think that's the biggest golden nugget I can probably leave for our listeners today.
I mean, that's absolutely huge. And to do that kind of, admin and make sure that everything is in order, because I think people assume that things will magically happen after they die, that people will be taken care of, but they won't. Johan, that was very useful. Thank you. Sinal, before we get to you, Sinal, I just want to say again to our audience, feel free to send in any questions. We've got two experts here, absolute fundies when it comes to winding up estates, especially for entrepreneurs and business owners where the matters can be quite complex. So please do send us your questions or queries. Sinal, just coming back to you, you're a self-confessed intellectual property and data protection nerd. I love that. What do business owners need to know about their intellectual property in the event of their death? You were mentioning earlier that there's many different kinds of property.
I mean, you mentioned having cut my teeth in corporate law, and when I worked in my two previous law firms, a lot of the work that I did was around due diligence when it comes to things like mergers and acquisitions, and it's a really good place to start. I mean, I think all businesses should hope for the best and expect the best of their businesses, and that you are going to get to a place where you are being acquired or merging with another business or something along those lines. And what I found a lot is that the thing that was of value that people were trying to acquire is maybe 90% of the time the intellectual property of a business. So it's things like who owns the software, who owns the recipes, who owns the processes. And when you start trying to dig down to find out who the owners are, it's we worked with this one person. Who is that? Oh, we don't work with them anymore. It's a situation of we didn't have the appropriate assignment agreements that we took ownership of it. And likewise, when you are starting out in a business at this stage, that intellectual property can be very valuable. But a lot of people forget that that's an asset and it's dealt with as anything. So when you think about your car, when you think about intellectual property of the business, they're the same thing. And if you don't have a will, I mean, that's maybe something that we should have started with, is if you don't have a will, the state has a mathematical formula. It's an algorithm that they follow to say who inherits what of your estate. So I've seen it a lot where lots of people say, I don't have a will because I don't own anything. And then you say, but what about the cash in your bank account? What about your car? What about your household contents? What about the business that you've been running for the last couple of years? And if you don't have it, it will go to your blood relatives. That's the further they move away from that relationship, that's kind of the order it goes into. So when you have something like a business with business partners or a life partner that you're not married to, the law doesn't recognize that. So it's just about understanding that intellectual property can be an intangible thing, but it shouldn't be forgotten about, because it's something I have yet, in all the businesses that I've worked with, I have yet to find a single business that can say confidently, I don't own any intellectual property. It's the same as I've yet to find a person that can say confidently, I don't own any assets. And it's just things like understanding that it doesn't have to look a certain way. Wealth doesn't look like you cross the threshold of X million rand. Wealth looks like I have 2 rand. I mean, that's something, you know, that 2 rand's got to go somewhere. And if you don't make provisions for it, the state is going to decide who that goes to.
I mean, it's fascinating that you say, you know, that some people just say we don't have a will. And I think people are very embarrassed about that, but it is fairly common, isn't it, Sinal?
Definitely. I think in South Africa, I mean, our stats are maybe a little bit outdated, but the last kind of survey that was done said 70% of South Africans don't have a will. So and I think that that's quite a optimistic, you know, estimate. And when we're looking at those 30%, I think that most of the people there are triggered when it comes to things like I've had a child or I've bought a property, and what's prompting them to have a will or life insurance is because it's a corporate entity that's saying, if you die, we stand to be affected. But that the 30% of people who have wills, I'd be very interested in. Something I'm very passionate about doing research into is how many of those are being proactive and have got these wills in place. There are lots of things. We've just had National Wills Week in September, where lots of people also have wills, but without even understanding what it means. They don't even understand who is the executor. Johan mentioned setting up testamentary trusts. Those are so important when it comes to minor children as well, because it's not that you can get away from it. People think, oh, but my spouse will look after the kids' inheritance. But the state says, if you don't have a trust for that minor beneficiary to have their inheritance sit into, we will put it into our trust, and that's called the Guardians Fund. Trying to access that money is very, very difficult. And
that's very useful to know, like that actually that it's a bare minimum, have a trust in place to put your assets into for your children. Don't assume that someone else will do that for you. Johan, I just want to come to you because you're used to working with corporate clients, these bigger clients, and I'm interested to know, before we get to audience questions, and please, if you're watching, please send in some more questions. We're going to get to that shortly. Johan, I'm interested to know what common mistakes are bigger clients making? You know, we maybe think that like smaller entrepreneurs are the ones that don't have wills in place, or don't have their admin in place. But are you seeing this at a higher level as well?
Absolutely. And Roshni, I think it brings me back to my first sort of points I mentioned. I think what tends to happen is we tend to forget about the basics, and just going back to making sure as the business owner, I'm sought after, because, you know, as the jockey, I'm in control, you know, and there's so many dependencies on business owners. And I think that's a fundamental place to start. And as Sinal said, you know, the starting point of any good plan, and I might get into the question that has just been asked. Any plan starts with a will. And I think one of the listeners asked, you know, do I have to have a separate will, you know, as an entrepreneur to my family? At this stage, you incorporate everything in one will, but it is such a holistic approach that the will is the starting point, because I always say it's the only document that steps in your shoes when you're not there, giving a set of instructions how your wealth will be distributed. And that's very rudimentary, but that's kind of, you know, what a will is. So, you know, that takes all assets into consideration. That means, you know, from an ownership perspective, how do you, and we spoke a little bit about the structuring and all that, but ultimately you'll have one will that looks after your business, because you own a piece of that business, and your personal assets. But together with that, you know, the holistic financial plan or estate plan that we're referring to, that's where you would ask questions about business continuity. Do I have business insurance in place? Is someone going to take over? Do I have key individuals in my company? You know, that nice example that Sinal used about, you know, sort of your employers are going down on a plane. What's going to happen? Do I have sufficient funding to make sure that I can get someone else to step in their shoes so that the business can continue? And just to answer that question, you will only have one will that looks after all assets, but you will take every single piece into consideration from business to person to make sure that you cross all the T's, dot all the I's.
So that's whether or not you're a sole proprietor, whether you're one of many directors in a big business, you put all your wishes to do with your business interests in your personal will. Is that correct?
And Roshni, it's like I said, it's a very tricky one to answer, just, you know, a simple yes, no, but it'll depend on who the beneficial ownership lies to, with those corporate structures, etc. But, you know, just to answer the question, you'll take all assets into consideration when drafting your will. That is business and personal. But we need to make sure that we look after the business continuity, business plans, the shareholder agreements, all those things that Sinal also use from a corporate perspective in putting our holistic plan together, because none of these tools can be read in isolation. It all needs to be seen jointly together to form the
I'm just
plan.
going to stop you there because we're running out of time, but that was an answer to Segamoto. I hope I said your name right. Segamoto Sibambato. Thanks for that question. The Baldwin Foundation has asked, so now maybe you can take this one. What about being married in community of property? I know that is a tricky one. And as you were saying, ex-wives pitch up, later on to get their dues. So what I don't exactly know what they're asking around it, being married in community of property, but maybe you can answer it generally.
Sure. So just to draw an analogy, when we talked about when you start a business and you operate as a sole proprietor, you are one legal entity. So often, as I mentioned, when people say it's me or you or us, what does that mean? And when you get married in community of property, what it means is that's the default in South African law. So everybody is married in community of property unless they choose otherwise. And there you need to have an anti-nuptial contract. And what that does is it creates two separate personalities. And it's a bit of a tricky thing because I guess romantically you want to become, this one entity, this one family. But legally, it does make sense to have separate personalities, especially if you're getting married to somebody or you both have your own businesses, or that's something that one spouse is anticipating doing in the future. That for me is a big flag that goes up to say you should be considering getting married in out of community or property, because it's the best thing to do to protect your family. So when you're married in community property and you're one entity, if you start a business and you get into some tricky waters with creditors, they don't see you and your spouse as separate people. They will go after you as one entity. It completely can affect your credit rating, which means that your spouse then can't buy a home or do any of those things as separate people. So that's very important. In terms of a will specifically, when you're married in community of property, it's very difficult to have separate wills. It's impossible because you have one pot that you're tapping into. And something just to quickly touch in, which I think is an important point when it comes to spouses and children, any dependents, everybody has their own lives and everybody's entitled to have their own private lives. But for example, if you have a mistress and you decide, I'm going to bequeath everything to this partner that I have, it doesn't mean that you can just exclude your spouse from that inheritance, because a spouse or your minor beneficiaries will always have a claim against your estate for maintenance. It's like when you get divorced. So when you get married, whether it's in community property, out of community property, you are creating obligations to that other person that divorce and death don't end. So you, just as much as you would have to pay maintenance to somebody who is dependent on you when you get divorced, your estate also has an obligation to look after your spouse and your children. Even if you say, today I'm going to bequeath everything I own, business and personal, to Johan, my spouse can still come to the estate, knock on the door and say, no, yeah. House, she paid for the school fees, she paid all our medical aid, these are our costs, and put it as a claim against the estate.
I mean, I think that would really, make sense for a lot of people who've heard those kind of cases in the news. You often hear judges ruling very favorably towards the spouses in those situations, because that is the way the law works. So Sinal and Johan, this has been absolutely fascinating. I just wanted to wrap up before we go ahead and see if there's any more questions. I think we've hit the last questions. One of the panelists is saying they're going to have to go and review their current will. But what I want to ask you guys is, okay, let me start with you, Johan. What is your advice to someone who's watching this and doesn't know where to start? They've got a business, their admin is in a mess. Where do they start?
I think, Roshni, a very good question. I think sometimes it's just knowing what we don't know is a good starting point, to understand that there is professionals out there to actually deal with you and help you through this journey. I think it is such a daunting field. You can get lost in it very quickly, but I say take the first step. get someone professional in and just ask the questions. I think just it's important that you go to a point where you say, what do I want to leave as a legacy one day? And you start from there and you build out, and all these structures and tools will fall in place, and you can get someone like a certified financial planner to help you guide you through these tricky waters. And I always say it's, you know, be good at what you're good at, but understand what you don't know, and go to someone that is professional to help you through these you know, tricky waters of estate planning and financial planning. But not doing anything is also saying something. And I think taking the first step is crucially important. And at least start with a will and get someone involved, and then work your way out. And it's, you know, you'll have a plan in place. But then just to maybe conclude there, Roshni, it is extremely important as life happens, and as you add new assets, or as you get married, or you venture into new businesses, always go back to the will, because ultimately there's one path that we all will walk one day, and that's death. And it's so important to go back to that plan and actually review that plan on a regular basis to make sure that it's intact, it's the most tax efficient, it's the most efficient, sort of mechanisms for my family, and take it from there. But I think just very simply, let's start, get a professional involved, and let's take the journey.
So, the classic saying, which is failing to plan is planning to fail. So just have a plan, start with a plan. So now, what are your last thoughts as we wrap up?
So just to echo what Johan was saying, is for me, done is better than perfect. And there was a very good question about, having two separate wills. The different way of looking at it is to say you must have one will, because when there's multiple things going on and it's not clear, what the date is, you're going to have contested wills. That all means court, that all means time and costs. So having a clear will is very important. One of the best things you can do is to start a will by saying, I revoke any previous wills that have been made by me, and to make sure that there's a proper date on it. And to Johan's point, it's about being organized, being detailed, and having as much information as you can without overcomplicating it. You don't want to, unintentionally create contradictions in your own will, and then that becomes, even more of a problem. So sometimes trying to keep it simplified is better. The best thing, I mean, we have this conversation with our clients all the time, is have conversations with people. I mean, I grew up in a family. My mom was sick for a very long time before she died, but we don't talk about death because it's, it's not PC, or it's too sad. I mean, I was trying to advise a friend and help her draft a will so that she could appoint guardians for her children and set up a testamentary trust. And she said, when she started writing, in the event of the death of me and my spouse, and she just burst into tears because it was too overwhelming to think of her babies being without their parents. And I understand that. And it is important to appreciate that we're all humans, but start having the conversations, normalize death, because like Johan said, it is something that we're all going to experience. And my partner Claire has always said that being prepared is like the best gift that you can give to your family, so that they can spend this time after you've died grieving and not being caught up in the master's office and lawyers and trying to find these documents, being able to say, I have been organized during my life so that when I die, here's the roadmap. And that's a big thing. I challenge people to get organized, but to communicate that, because it's all good and well when you have all these things in place, but you haven't told anybody. So, it's coming across your wishes 6 months down the line, a year down the line. You also deprive your family, one, from that opportunity to grieve, but two, to actually fulfill your wishes. So I think that's really important, is to just keep the communication lines open.
We're coming to the end of our session. We unfortunately run out of time, but I just want to say thank you both of you so much. We've got one last question, but I don't think we have time for it, unfortunately. It's quite a tricky issue that he's asking about. I'm sorry about that, Jason. We've run out of time. We've gone over time, actually. But Sinal, thank you so much for those last words. Johan, thank you so much for your advice, and even just taking us through these very complex waters so easily and explaining those concepts to us. We appreciate you both so much. Thank you to the audience that was watching. Thank you to Ventureburn for making this possible. And of course, thank you to Absa for sponsoring this talk. Go home, go look at your documents, look at your latest will, create a will if you haven't already, download all your latest policies and make sure that you've got your beneficiaries noted down correctly. And let's get organized so that we can protect our loved ones should the worst happen. Thank you.